dar início, então, ao terceiro painel. E é uma alegria enorme para a equipe de pesquisadores aqui, Kevin, Guilherme, eu, contarmos com a presença da professora Sara, da Duke University, que tem, bom, entre uma vasta pesquisa, alguns trabalhos justamente sobre double jeopardy, que foram muito inspiradores para o tipo de questão que nós estamos discutindo aqui. E o professor Ada Nieto, da Universidade de Castilla-La Mancha, que já estava conosco nos debates anteriores e que tem trabalhado diretamente sobre o tema da persecução criminal e da responsabilização das pessoas jurídicas. Bom, como eu disse a vocês no início, hoje pela manhã, nós faríamos algumas bastante breves introduções. Está funcionando? Algumas introduções sobre as questões que nos interessam, trabalhar especificamente em cada um dos painéis. Então, após a discussão sobre a investigação, nesse aqui nós vamos focalizar a questão das sanções, né? E algo que é bastante característico do sistema anticorrupção, não só no Brasil, mas nos outros países que nós analisamos na pesquisa, que é a possibilidade de cumular sanções na esfera penal, civil e administrativa em relação aos mesmos fatos. Então, a questão da duplicidade de sanções, ou, em alguns casos, em alguns países, a possibilidade de até mesmo 3 sanções serem aplicadas aos mesmos casos concretos, porque aplicadas por diferentes autoridades, por intermédio de diferentes procedimentos. Bom, isso, nos países que nós analisamos, assume diferentes feições, mas aqui no Brasil, especialmente, eu queria fazer só uma notinha para um pouco explicitar para vocês, porque este tema nos parece ser central para um tipo de reflexão que estamos fazendo aqui sobre a coordenação interinstitucional no enfrentamento à corrupção. Então, aqui no Brasil, nós temos, no nosso aparato normativo, a possibilidade de que uma mesma situação concreta, um mesmo caso de corrupção, um desvio de dinheiro em obra pública, por exemplo, ou qualquer outro tipo de situação concreta que possa ser tipificado, visualizado por intermédio da ideia de corrupção, ao menos 3 tipos de procedimento podem ser iniciados em função desse caso concreto. Na esfera administrativa, como discutimos no painel anterior, com o Mário Spinelli e com o Roberto Biasoli, que ainda está conosco. Tem um lugar para você aqui, Roberto, se você quiser sentar conosco. A esfera administrativa, que aplica sanções, né? Desde a Constituição de 88, os nossos procedimentos administrativos estão submetidos também ao devido processo legal, e as sanções são aplicadas e executadas na esfera administrativa. E, por exatamente esses mesmos fatos, é possível haver em nosso país também uma responsabilização na esfera civil, o que é muito difícil de explicar para outros sistemas jurídicos, como é que isso pode ocorrer. Mas isso, no nosso país, ocorre em virtude da Lei de Improbidade Administrativa, que estabeleceu que a ação civil pública é o instrumento, é o procedimento adequado para a persecução e o sancionamento das infrações à Lei de Improbidade. Então, aquele mesmo desvio de verba pública, que pode ter sido objeto, por exemplo, de persecução e sancionamento no âmbito do Tribunal de Contas da União, pode também, e muitas vezes submetido a uma ação civil pública, que também pode resultar numa formulação de responsabilização, né, por parte do Estado e na determinação de sanções também relacionados à esfera pecuniária, multas, dever de reparar o dano. E esse mesmo fato, mas agora exclusivamente relacionado às pessoas físicas e não jurídicas, que puderam ser responsabilizadas na esfera administrativa e na esfera civil, podem ser responsabilizados criminalmente. Então, esta possibilidade de uma tríplice persecução e de, portanto, uma tríplice sanção é algo que nos parece especialmente importante se estamos pensando como coordenar e, se é necessário, coordenar esse tipo de instituição. Como eu indiquei para vocês no início, nessa pesquisa, para a gente facilita muito pensar de maneira diferenciada cada uma das funções, né? Então, a função de investigação, a função de responsabilização e a função de sanção, porque tem outras regras, tem outras questões em jogo quando estamos trabalhando cada um desses elementos, né? Cada uma dessas funções. Então, no âmbito das sanções, as questões que aparecem aqui mais prementes dizem respeito a como pensar a proporcionalidade das sanções, né? Um princípio que é muito caro no âmbito do direito penal, que é a proporcionalidade da pena. Se aqui pensado de maneira um pouco mais ampla, imaginando que outras instituições, por intermédio de diferentes procedimentos, também aplicam sanções, como é que, pensando a rede ou conjunto de procedimentos que são desenvolvidos em relação ao mesmo caso concreto, como é que essas sanções poderiam ser coordenadas ou não? Aplicaríamos as três? Deveriam ser compensadas umas às outras? Ou deveriam a autoridade subsequente deveria levar em consideração as decisões anteriores? Enfim, tem uma série de questões agora para serem pensadas, tanto do ponto de vista do Estado, que está utilizando, mobilizando um grande conjunto de recursos para perseguir e responsabilizar essas práticas e que, portanto, pode estar fazendo 3 vezes um trabalho relativamente semelhante, ainda que com roupagens muito distintas, mas também nos parece importante pensar esse problema a partir da perspectiva dos indivíduos, dos cidadãos apenados, sancionados, que podem necessariamente, em situações como essa, viver a necessidade de mobilizar um conjunto de advogados de diferentes áreas e também receber sanções que não estarão diretamente relacionadas ou com um estabelecimento de proporcionalidade em relação ao fato, porque o fato foi um só. A proporcionalidade que foi pensada, que fica em questão aqui, é a proporcionalidade que está vinculando apenas à sanção e aquela tipificação da esfera civil, penal ou administrativa que foi violada. Então, é com esse conjunto, na verdade, de questões que eu gostaria de abrir essa mesa e passo a palavra diretamente à professora Sara. Muitíssimo obrigada.
I would like to first express my great happiness at being at this conference. I've already learned a lot this morning and very much appreciate the invitation to speak to you. I will eventually come to the question that was presented, but in order to be able to explain it, I want to talk a little bit about how the U.S. system is set up at a pretty general level, and then come back to this question of double penalties, double prosecutions, and so forth. I think that you could say that the most important theme from our point of view is deliberate fragmentation of government authority. And I'm sure everyone in the room is very familiar with the fact that the United States is composed of 50 states. We have a federal government and state governments, and that was a very deliberate constitutional choice. You may not be aware that a great deal of authority is actually also delegated within the states to the local governments. And this is very pertinent to criminal law enforcement because at the federal level, we actually elect our chief prosecutors, usually at the county level. So there are more than 2,300 elected local prosecutors, all right? So not only is authority pushed down from the federal government to the states who have general criminal authority, and certainly authority over, for example, misconduct by their own government officials, that authority deliberately by state constitution is then further fragmented, divided, if you will, deliberately fragmented and divided to these relatively small local units. So I'm at Duke University in Durham, North Carolina. We elect our local county prosecutor. We also elect our sheriff, right, along with our mayor and so on. So it is a divided authority, and prosecutorial authority is politically controlled, deliberately politically controlled. And at the state level, in most states, you also have an elected attorney general. So we have authority divided, and we have political control at the state level. At the federal level, there is, very important for our purposes in terms of corruption, also federal prosecutorial authority, and that is indirectly politically controlled as well. We talk about having a unitary executive, meaning we only elect one person, the president. Really, we elect a vice president. They're on a ticket together, right? Everyone else in the executive branch is an appointed official. The Attorney General is appointed by the President and confirmed by the Senate. He or she will always be of the President's party. Then federal authority is further, you know it's coming, fragmented or divided to the 94 districts, and those United States attorneys in those districts are of the President's party, nominated by the President, confirmed by the Senate. So it's clearly a political appointment to carry out certain policies, goals, and so forth. All right? So we have a pattern. We have a pattern where authority is deliberately divided, and those lines of authority at the state level are political subdivisions, the states themselves and then the political subdivisions within the states, with the idea that the local voters control and have their own goals, policies, et cetera, which would not only govern the Board of Election and what policies the election, or excuse me, the Board of Election, the Board of Education, right? It also would govern prosecutorial authority. So, for example, some of you may have heard of our very harsh sentencing laws, like 3 strikes and you're out, the 3 strikes. All right, so prosecutors in California, the harshest state in the country, prosecutors in California ran on the political campaign either, I will be very hard, I will always apply the 3 strikes law, or I will not use it in all cases. I will restrict its use to the most dangerous people, right? And their voters could choose what they wanted. I think you can see what implications this will have as we go along here. Now, authority then in the state level is largely pushed down to the state prosecutors. The exact arrangements, however, vary state by state. So in some states, the Attorney General at the state level has some greater power and authority and may have special investigative powers or may not. Each state has its own theory, and many states have amended their constitutions many times. In fact, some people have called it hyper, like too much, hyper-democracy. So criminal justice policy is very much a matter of political debate, and at certain points in time and in some places, that's reflected not only in laws like the 3 strikes laws, but even in constitutional design and amendment. California, again, kind of stands out there not only on the coast, but as a policy matter. Just about every electoral cycle, they will have ballot initiatives, many of which will amend the Constitution. And they'll get a big packet, each voter, get a big packet in the mail of educational materials, 1 page on each proposal. Right? So all of this is very deliberately, democratically controlled, and very much that authority divided out into different small subdivisions, and then some overlap in authority between, in many states, the state attorney general, the local prosecutors, right, and then the federal government. So when you think about investigative resources at the state level, you'll have the State Bureau of Investigation, the SBI, you'll have the local police authorities, and the SBI may have no control over the local police, and the local police have no control over the SBI, and the Attorney General has no control over the local police. All right, there's a deliberate effort to make sure there's not too much power in any one place. That's the underlying kind of intuition, that it is better to divide up power, a concern that the second panel this morning, talking about coming out of a period of an authoritarian regime. The U.S. Constitution and many of these state models came out very much out of concern for an authoritative regime, too much central power in the federal government. So we have that as a backdrop. Now, the states, because they have plenary authority under the Constitution, they have full government powers, they obviously have the authority to pass legislation and enforce legislation concerning corruption by their state officials and their local government officials. And all of them have some laws of that nature. They vary widely. And I hope that I'll have time to come back to that and talk about one particular example. The federal government also obviously has authority, and Congress had authority, to pass legislation that would make it a crime for federal officials to be corrupt, for federal judges to take a bribe, for congressmen to take a bribe. Some of you may have read about, maybe 4 years ago, about a congressman popularly known as Dollar Bill Jefferson, right? He always was looking for dollars, and literally they found cold cash. He took, in a sting operation, an undercover operation, he took a big wad of cash, put it in tin foil, and put it in his freezer. And it was there when the search was done. They found the cold cash. I believe it was in a pizza box in his freezer. So obviously the federal government has the authority in this divided system to prosecute corrupt congressmen, secretary of what was he at that point? Agriculture. SB was under investigation. A senior member of the administration. A federal meat inspector. They obviously can prosecute that. But Congress has been very interested in and busy in thinking of employing its delegated authority in ways that give it provide more opportunities for federal prosecutors and federal investigators to be actively involved in the prosecution of corruption by state and local government officials. That doesn't seem so obvious, does it? I mean, if there's really a divided authority, what would be the basis for the federal government to have that kind of oversight over these independent sovereigns that came together and only gave it limited authority? There's nowhere in the federal Constitution that says the federal government should police the internal affairs of the state and local governments. However, there are multiple federal crimes that have been and can be employed to prosecute corrupt state and local officials. One of them is anti-bribery provision, 18 U.S.C. 666, and it allows the federal government to prosecute any state or local official who takes a bribe or demands a bribe if in connection with a transaction that's worth at least $5,000. It's not very hard. If the state or local government unit receives at least $10,000 in federal funds. So it's following the funds, and we think every state and local government gets at least $10,000. And the Supreme Court has held that the bribe doesn't have to have a close connection to the federal funds. All right? As the Supreme Court said, money is fungible, which it is. If you are cutting corners over here because somebody bribed you, right, that will weaken and federal dollars might flow over to make up for that, or in fact, corrupt agencies are not likely to be very effective, right? So that's one way that the federal government can do it. Federal law also criminalizes the use of the mails or the wires, which would be your cell phone, your email, anything else like that, for a scheme or artifice to defraud, including a scheme to deprive you, the victim, of honest services. Meaning, a public official who takes a bribe or a kickback has deprived his constituents and the government of his honest services. So that can be prosecuted. And how many of these deals involve at least a phone call, a letter, an internet, a text message, meet me at, right? So that's very widely available. And then, as if that were not enough, there's another relevant federal statute, which we call the Hobbs Act, which makes it a federal crime to commit extortion under color of official right, which means bribery, if it affects interstate commerce, interstate or foreign commerce. And just about anything will meet that standard. If a business's assets are depleted even by a couple of $100, that is said to affect interstate commerce. So you see, we have both a deliberate decision, very deliberate decision to break up power and authority with decision-making, policy-making, pushed to the states and then down to the state and local governments, limited authority at the federal level, but also these potentially very broad statutes that can be employed by federal prosecutors, can be and are employed by federal prosecutors. With that in mind, and I should also say that there's other legislation that was federal legislation referred to earlier today, the Foreign Corrupt Practices Act, and that might well cover conduct that would be illegal under state law as well as under federal law, depending on the fact scenario. So we could iterate out more overlaps, all right? But there are many, many, many built-in overlaps. Now, that brings us to the question, I think the heart of the question that you were speaking of. So let's talk about why there is a federal interest, if there is, why state and local officials might be prosecuted by the federal government, and then how we think about these questions of multiple actions, multiple punishments, and so forth. Our most recent high-profile conviction of a state official occurred about 10 days ago. The ex-governor of Virginia, who's been out of office for less than a year, was convicted by who? By a federal jury in federal court for wire fraud, federal program bribery, and so forth, all of these offenses. He had taken from a businessman who wanted his help in a variety of ways, getting state researchers at the state university to consider doing studies of his product that would show its effectiveness, meeting various important state officials and so forth. He received I think it was about a $17,000 Rolex watch that said 71st governor of the state of Virginia. His wife received designer ball gowns for the inaugural ball. The businessman paid for most of his daughter's wedding reception. There were thousands of dollars at golf clubs for greens fees, drinks, dinners, and so forth. So it was a large stream of benefits to the governor. It was not, as far as the commentators can tell, illegal under state law. It was not illegal under state law. He reported most of it. Virginia had a reporting system. You had to report things. So if he got a watch that said governor and he reported it, apparently under state law, that was it. However, the belief was it was actually essentially a bribe. right? A series of benefits to cause him to take action that he would not have otherwise taken in his official role to benefit this particular company and individual. So, federal grand jury indicted him. The federal prosecutor took the case with the assistance of the public integrity section in Main Justice in Washington, and he was convicted. So there is a belief on the part of many scholars and certainly many federal officials that there is a strong federal interest in the prosecution of state and local officials. I believe at most recent count, the last 4 governors of Illinois have all been convicted on federal charges. The most recent was Rob Blagojevich, who was caught on tape talking about how much he was going to demand for the person that he would select as Barack Obama's replacement in the Senate, U.S. Senate. The state governor had that authority. All right. Why do we need federal prosecutors? Well, maybe it's too hard for anyone in the state to go against the governor. All right. So how can a local state prosecutor have the authority to do it? But not all of these prosecutions are of the state governor, and not all of the state laws are as deficient as Virginia's. And you'll be, I hope, pleased to know that after the McDonald prosecution became a very high-profile issue, Virginia did amend its laws, right? So it now has more comprehensive laws, and they say they will pass more in the future. So in many cases, the officials that are prosecuted by the federal government are fairly low level. So they might be a city councilman, right? And one would think that that's not such a powerful person that no state or local prosecutor could go against them. So we do have this potential for multiple punishments by the federal government and by the state government for what is clearly within, I think, the definition of what we would call corruption. Okay, so what's the law on this? Potentially we can draw on federal constitutional law, some federal regulations, and state constitutional law and state statutes, right? So we could find a limitation in any of those. If the state prosecutes first, if it does, as a matter of federal constitutional law, there's no barrier to a second federal prosecution. If the federal government prosecutes first and the state prosecutes second, again, under the federal double jeopardy clause, there is no bar to a second proceeding, even if it's the very same conduct and the federal law requires a bribe and the state law requires a bribe. You're proving the very same thing. And even if the defendant is acquitted in the first proceeding, there's no bar. Why? A doctrine called the dual sovereignty doctrine. Two sovereigns. So Virginia is regarded as a sovereign that has control, policy-making control, political control of its own laws, and the federal government cannot preempt its enforcement of those laws. Similarly, Virginia cannot preempt the federal government's enforcement of its laws by either doing a bad job and getting an acquittal, doing a good job, not getting a high enough sentence, not fulfilling whatever is understood to be the federal interest here. And this issue was most recently highly publicized in the case of a citizen named Rodney King. Is that, anybody in this room know the name Rodney King? The guy who was beaten on tape by the California Highway Patrolman. All right? And it was the first really highly publicized television where people saw something happen. Over 90% of people in the United States said they'd seen that tape within the first month. Most of them had an opinion about what had happened. The first trial was a state trial, and the patrolmen were acquitted. It led to a massive riot in Los Angeles, leaving many people dead, thousands of buildings and businesses burned down. It was catastrophic. And the federal prosecutors and investigators who had been following the case as a matter of federal civil rights law from the main Justice Department, as soon as the verdict came down, the Attorney General said, get on a plane and get out there. That plane couldn't land in Los Angeles. There was so much smoke, they were diverted to Las Vegas. And so they drove in, and there were charred trees all around the federal courthouse. It didn't get to the federal courthouse, right? But it was a disaster. And they were able to prosecute for the very same conduct, and they had to prove that it was a knowing violation of his civil rights, and they got a conviction. Right? So very recently, we've seen this high-profile example. It may be that the state prosecutors just weren't as good. They didn't have as many resources. During the civil rights era, often the state officials were the problem, not the solution. People died in state custody of beatings, and state didn't seem to know anything about it. Right. So there may be a conflict between federal and state. There may be a sense that state officials don't have the resources or the training. It's really very interesting to talk to the people that prosecuted that case, who had a lot of experience in these cases where you have to interview a lot of police and no one will tell on the others and so on, how to do that procedurally. So the federal double jeopardy clause is construed to recognize this separation of authority and full independent authority on the part of each of the two sovereigns, neither of which can block the other, right, by ineptitude or sneaking in there first or what have you. All right. State law, however, may be more restrictive. I mentioned the difference from state to state in terms of constitutions. Some states have some constitutional limitations on a second prosecution. And about half of the states have legislation that limits the ability to bring a second prosecution. It's a matter of state law, and their tests are a little different. Sometimes if you have new evidence, you can bring a second prosecution, right, even if another sovereign has prosecuted. So state law is going to vary. If federal goes first, states may or may not be able to go, depending on their own sense of fairness, efficiency, and so on. But that would be the state's decision built into their constitution or their statutes. So the federal constitution imposes no limitation on a second prosecution. Congress has imposed no limitation, unlike these half of the states that have statutes that limit it somewhat. But there's an internal administrative restriction for the Department of Justice called the petite policy, like the little policy, the petite policy that limits when second prosecutions may be brought. And you must get authorization essentially from the senior administrators in the Justice Department. And you have to show that there's a federal interest that has not been met. So perhaps the state did a bad job and was unable to secure a conviction. Perhaps the state prosecuted for a very minor offense and the punishment was insufficient. Perhaps the state punished for a serious offense, but for some reason the judge said, oh, it doesn't seem that bad to me, right, and gave a low sentence. So as an administrative matter, the Justice Department has a requirement that you go through very careful evaluation to determine whether a second prosecution should be brought and when that applies. All right? And it is decided at a central level, not by the 94 U.S. attorneys. And in fact, if the defendant is convicted and it's discovered on appeal that the U.S. attorney didn't follow the correct procedures, they will confess error, and they will tell the court, dismiss the prosecution, this was not approved. It doesn't meet our standards. So there's a very strong enforcement of that norm within the Justice Department, but it's no one else's choice. It's the senior prosecutor's choice at the central level, and the policy is quite long and detailed. So one can read it and decide whether you feel it is the right issues and the right process and so on. But because double jeopardy provides no real limitation, the double jeopardy clause of the federal Constitution, an individual charged with many, many, many different kinds of crimes. So like the patrolman who assaulted Rodney King, like the governors of Illinois, who probably did violate some Illinois law, and so forth, all of those people potentially face the prospect of 2 prosecutions, just depending on what their state law permits. And of course, I would say of course, they may also face dismissal from office. They may face some kind of private civil lawsuit. And I would say from the perspective of U.S. law, that makes perfect sense because the function of different causes of action is different. So the function of a criminal prosecution is to punish the defendant. The function of a civil proceeding is generally compensatory. Right? And the function of an action to remove an individual from office is to get them out of office, right? And we would not regard that as inappropriate, right? So we wouldn't, it might not be efficient to do it in separate proceedings, but we really don't have a way to draw all of that together in many cases. Now, the punishment under some statutes does include inability to hold office. Right, so that could be a part of a federal sentence, and what's allowed under state law is a matter of 50 state laws. Even where double jeopardy applies, the test is the protection is very narrow. So it only protects you against being punished for, quote, the same offense. And as I suggested, the conduct of a person such as Governor McDonald might trigger several different statutes, and if the proof overlaps to some degree but not in other directions, they might be held to be different offenses. Right? So there might even be possible to have 2 federal prosecutions back to back. So I would say that double jeopardy does not impose any very substantial limitations. And that it reflects a choice, which, coming back to the themes of the conference, reflect a notion that cooperation is fine if the federal and state officials want to work together in a task force, but it's not required, and neither can preempt the other. And at the state level, the various units may cooperate, but they cannot really control one another generally. And I think it's thought that on the whole, this is beneficial. So there is a kind of competition. I think the officials in Virginia were quite embarrassed that their laws were insufficient, no action had been taken when the federal prosecutors were able to move on that. And if you have one inept or corrupt group, as in the Illinois state government, you have a second player that can come in and fill the gap, right? So that kind of duplication of authority is better, I think, than the Hong Kong model of having everything be very unified. And there is some kind of competition among investigators and prosecutors and so forth. And I'm not sure about my time. Should I stop now? Pardon?
We could hear it for hours.
But perhaps I'll stop now? 5 minutes?
Yeah.
Well, I did want to say a little bit about enforcement authority at the federal level, because again, this question, how do you discover what kinds of problems there may be? Most of you probably remember the history of the Watergate affair, Richard Nixon having to resign as president, and a sort of major scandal. A number of federal pieces of legislation that are good government or anti-corruption and so forth, pieces of legislation stem from that post-Watergate era. And they illustrate a couple of points about the detection of corruption, fraud, and so forth, and the measures put in place at the federal level to try to create structures that will reduce the likelihood that this would occur and make it possible to prosecute when they do occur. So Congress was very active. There was a move to impeach President Nixon. There were lots of hearings and so forth, and the post-Watergate hearings included a lot of information about companies making improper political contributions, having big slush funds, bribing foreign governments. That's when the FCPA, the Foreign Corrupt Practices Act, was passed. It's a direct outgrowth of that. That is when the Inspector General legislation first came into force, and the GAO, the Government Accountability Office, received a lot of its authority at that time. So the GAO, the Government Accountability Office, is an independent, nonpartisan agency. It works for Congress and it investigates the spending of taxpayer dollars, and it audits agencies, it investigates allegations of illegal and improper activities. It provides very extensive reports on government programs and policies. It performs analyses of options, and they have a large staff of auditors, of criminal investigators, all right? And they seek to ferret out misconduct throughout the government. The inspector generals are located in each agency throughout the federal government, and they have very extensive authority. They audit, they kind of on two sides. So part of it is really a criminal investigative audit, so for something like procurement fraud. So the Inspector General of the Department of State, there are all these embassies all over everywhere, and they buy a lot of things, right? And they're in different places, and so some of that is looking at procurement fraud, but some of it is looking at the effectiveness of that embassy. So they have people that carry guns and have badges, and then they have former ambassadors that go out to each I think every 5 years, each embassy gets visited. So these entities are very interesting. They have everything from the authority to figure out that some employees aren't doing a very good job, and they might be demoted or fired for that reason, or they're corrupt, or they're being defrauded by someone selling things to them. And those inspectors general speak to the head of the agency, but they're supposed to report to Congress too, right? So there's this dual quality. And again, Congress trying to sort of monitor the effectiveness and the integrity of these various federal officers and programs. And I do want to mention one other statute, which is not a new one, but its enforcement has really been ramped up, and that is the False Claims Act. So if you're thinking about procurement fraud and that kind of thing, who's happy? The company paying the bribe and the employee that's getting it, both sides, everybody's happy, who's going to complain? Often someone knows, and that whistleblower, do you know that yeah, okay, that whistleblower can get a very large recovery by bringing suit under the False Claims Act. And so we have incented private parties, and Congress is going more and more in that direction, incenting private parties not just to write letters to the editor, but to report to the Inspector General or to the federal prosecutor that some kind of misconduct is going to file his own lawsuit, right, in the name of the United States, right, and then get a third of the recovery. These different channels are available at the federal level, and if anyone wants to follow up on any one of those, that would be very interesting too. But I know that I've taken more than my share of time. So thank you for letting me be here today.
Bien, buenas tardes. Y repito mi agradecimiento a los organizadores de este seminario y mi enhorabuena por el paper que, aunque es provisional, nos han presentado. Yo llevo tiempo con esto estudiando la corrupción y la verdad es que ha sido como aire fresco, ¿no? Una perspectiva distinta a la forma de abordar estas cuestiones. He aprendido mucho. Bueno, voy al tema que me compete, que es el principio de ne bis in idem. Y entiendo que cuando los organizadores han formulado o han planteado esta mesa, latía en ellos la siguiente pregunta. ¿Es el principio de ne bis in idem un buen principio para coordinar procesos y sanciones? Es decir, en esta coordinación que buscamos, ¿esto nos sirve? Y mi respuesta, ya se la adelanto, es no. El principio de ne bis in idem, no busquen coordinación, porque es un principio muy oscuro, que cambia de país a país y casi de persona a persona que lo piense. Porque hay como dos grandes concepciones de qué es el ne bis in idem. Unos, yo me sitúo en esta, lo entiendo como una sanción a los órganos estatales, que les dice, mirad, solo podéis sancionar una vez por un mismo hecho. Si os equivocáis, lo sentimos. No podéis imponer una segunda sanción. Es una sanción al Estado. Esto es terrible, entre comillas, porque fíjense lo que pasó en España, que era la posición que mantenía nuestro Tribunal Constitucional. Una empresa que había contaminado un río, enseguida dijo, bueno, pues tengo una sanción administrativa y tengo una sanción penal. En el procedimiento sancionador administrativo se trata de pagar una multa, voy a conformarme enseguida. Pago la multa y así me libero del proceso penal. Es decir, es verdad que esta regla nos lleva a algo tan irracional como el primero en llegar, primero en servirse. Quien llega primero sanciona, aunque sea la sanción más baja de todas. Ojo, esto puede parecer irracional, pero entre los países de la Unión Europea, ahora veremos, sí que aplicamos el principio de ne bis in idem, es la que sigue el Tribunal de Justicia de la Unión Europea. Es decir, si hay una sanción en Italia y puede por los mismos hechos haber una sanción en Alemania, y primero sancionan los italianos, porque, por ejemplo, se llega a un acuerdo, la sanción que vale es la italiana, aunque haya sido una sanción muy pequeña. Bien, una segunda forma de entender el ne bis in idem es entenderlo como una manifestación del principio de proporcionalidad. Hacía referencia. Claro, esta forma de entenderlo rebaja el contenido del ne bis in idem, porque al final lo que se controla es que de alguna forma el conjunto de sanciones que se imponen sean proporcionadas a la gravedad del hecho. Esta es la forma que entiende ahora el Tribunal Constitucional Español el ne bis in idem entre sanciones penales y administrativas. Y dice, si sanciona primero la administración, no importa, se puede abrir un procedimiento penal, pero después el juez penal tiene que tener en cuenta que ya han impuesto una sanción por los mismos hechos. Lo tiene que descontar. ¿Cómo? Pues vimos a ojo, lo que le parezca. No hay una regla fija. Bien, tercera cuestión que se cruza aquí para que todo sea menos claro. Es la cuestión de la soberanía, a la que ha hecho referencia. Claro, resulta curioso que Estados Unidos, que es un país federal, no admita, como acabamos de ver, el principio de ne bis in idem entre sanciones federales y sanciones estatales o entre sanciones de distintos estados. Resulta curioso porque en la Unión Europea, que no somos, estamos ahí que no sabemos qué somos, si somos una organización internacional o somos ya una federación de estados, estamos ahí. Bueno, pero un rasgo muy claro de federalismo en la Unión Europea es que sí admitimos, el Tribunal de Justicia de la Unión Europea aplica el principio de ne bis in idem. Y además de esta forma tan rigurosa, de decir, el primero que sanciona, ahí se termina todo. Claro, como aquí se mezcla una cuestión de soberanía, algo donde no está para nada claro el ne bis in idem es en el ámbito del derecho penal internacional. Y cada vez tenemos más normas, y el caso de la corrupción es un ejemplo. Se ha citado la Foreign Corrupt Practice Act o la Bribery Act, o en general todas las leyes que son hijas de la Convención de la OCDE, lo que hacen es que extienden la capacidad de los Estados para perseguir delitos, hacen como una red de posibles jurisdicciones, pero después no dicen nada del principio de ne bis in idem, de tal forma que una empresa o una persona se arriesga por un mismo caso de corrupción a poder ser procesada en varios países. Pero en el caso del ne bis in idem internacional entre Estados, desde luego aquí no hay ninguna solución, ¿no? Algunos países aplican lo que llaman el principio de cuenta, que es una manifestación más de la proporcionalidad, es decir, tienen en cuenta la sanción que ha puesto un Estado en la sanción que ellos calculan, pero como una especie de gracia, ¿no?, que hacen. Bien, pero por si todo esto fuera poco, oscurece bastante el principio, todavía más, el principio de ne bis in idem, el que no sabemos qué es una sanción a los efectos del principio de ne bis in idem, es decir, cuál es el concepto de sanción. Tenemos claro que 2 penas privativas de libertad sí se aplica. Pero a partir de aquí ya empieza la oscuridad, ¿no? En muchos países, por ejemplo en España, sí que está claro que también se impone a las multas, a las sanciones pecuniarias que impone la Administración, ¿eh? Pero esto ya no está tan claro en otros países. Después tenemos otro tipo de sanciones, que son las sanciones disciplinarias, que son como una sanción distinta a las sanciones administrativas. Y aquí también la solución que se le da es bastante oscura. En unos sitios sí, en otros sitios no se admite. Incluso en nuestro país depende de la sanción administrativa. Y luego, para acabar, tenemos una serie de sanciones sui generis, que emplea la Administración, que aquí todo es también, más bien no. Sería, por ejemplo, tipo de sanción sui generis, el debarment y las listas negras, ¿no? Esto, que también podría ser una sanción penal, es un tipo de sanción administrativa, y aquí nadie estaría dispuesto a admitir el principio de ne bis in idem. Y se imponen conjuntamente. Bien, todo esto se dificulta. Les estoy intentando mostrar una visión de derecho comparado, porque el derecho sancionador administrativo, eso que llamamos derecho sancionador administrativo, es de los términos que a mayores interpretaciones se presta, ¿eh? Solo en la Unión Europea existen como 2 familias de derecho sancionador administrativo. Y aunque empleemos la misma palabra, hablamos de cosas distintas. Por ejemplo, para los alemanes y en general austriacos, también en Portugal, en varios países, el derecho sancionador administrativo es algo que se desgaja del derecho penal. Es decir, llega la Ilustración y se dice, aquí los únicos que sancionan son los jueces. Pasa el tiempo y ven que los jueces tienen demasiadas infracciones que castigar. Entonces, lo que buscan es aligerar el derecho penal, quitar una serie de sanciones y que estas sanciones pueda sancionarlas la Administración, pero con unas reglas muy de derecho penal, muy de derecho penal. Y al final quienes conocen de estas sanciones, los recursos, son los jueces de lo penal. Y aquí existe gran coordinación, porque los jueces penales, cuando en un mismo proceso puede haber una sanción administrativa y una sanción penal, hacen lo que nosotros llamamos concurso de delitos, es decir, las juntan o las interpretan. Bien, luego estamos otra familia, para quienes el derecho sancionador administrativo no tiene que ver nada con el derecho penal, no es un hijo del derecho penal, es un hijo del derecho administrativo, es una facultad del derecho administrativo, de la administración, para dar mayor eficacia, mayor vigencia a las normas. En esta familia nos ha costado mucho más entender el principio de nevis in idem, aunque al final también lo aplicamos. Imagino que en Latinoamérica, pues claro, habría que ver qué modelo y qué concepción de derecho sancionador administrativo se quiere. Bien, les he dicho entonces, aquí acabo la primera parte, que yo creo que esto no vale de regla de coordinación. ¿Qué sí podría ser una regla de coordinación? En primer lugar, las reglas de conflicto de jurisdicciones. Esto es claro, sobre todo en el nevis in idem internacional, pues, habría que tener una serie de reglas diciendo quién tiene mayor derecho a, en primer lugar, plantear un conflicto o quedarse con el caso. El problema, quién sería el juez que en caso de discordia decidiera sobre quién es el competente, ¿no? En la Unión Europea tenemos bis in idem muy fuerte, pero hasta el momento hemos sido incapaces de darnos reglas sobre conflicto de jurisdicciones. ¿Por qué? Porque entonces ya necesitaríamos un juez penal que decidiese sobre el conflicto de jurisdicciones y no hemos sido capaces de dar este paso. Pero bueno, dentro de un mismo país y administración, tribunales, esto, ¿por qué no?, se podría hacer. Segundo remedio, es de técnica legislativa, es decir, hacer buenas leyes, leyes que no se solapen unas a otras. Es decir, el legislador, el que hace la ley, cuando castiga algo, debe ver si eso ya lo castiga en otro sitio, ¿no? Los problemas de nevis in idem en España vienen porque se hacen demasiadas leyes y cuando se hace una ley nadie piensa que eso que está castigando de alguna forma lo has castigado ya en otro sitio. Entonces, este sería el segundo consejo. Hagamos buenas leyes. Y el tercero y principal, pensemos cuál es la finalidad de las sanciones y que cada sanción tenga una finalidad distinta. Es decir, las sanciones penales deben servir para la retribución o para la intimidación. Las sanciones disciplinarias, pues yo las sanciones disciplinarias en el marco de la corrupción las vincularía a un código ético, al código ético que debería tener cada administración pública y serían la forma de reforzar el código ético. Es decir, no tanto la ley en general, sino el propio código de conducta de que se dote cada administración. Y fíjense, en este código de conducta pienso que se sancionarían cosas que no necesariamente son delitos, ¿no? Los códigos de conducta en la administración o en las empresas deben servir también para poner lo que nosotros llamamos normas de flanqueo, es decir, normas que no sean el corazón de la prohibición, pero que nos ayuden a cumplirla, ¿no? Entonces, esta debería ser la función, a mi juicio, del derecho disciplinario. El sistema de listas negras o el debarment, yo creo que tiene una función inocuizadora. Es decir, la función que habría que darle a las listas negras es decir, hay determinadas empresas de las que no nos fiamos, porque han demostrado que nos engañan. Y mientras no nos demuestren lo contrario, las vamos a incluir en una lista negra, pero no como una sanción preventivo, intimidación o retributiva, sino inocuización, incapacitación. De tal forma que si esa empresa nos demuestra que empieza a hacer las cosas bien, por ejemplo, se dota de un sistema de cumplimiento, cambia sus directivos, lo que sea, nosotros la sacamos de la lista negra. Pero la finalidad de la sanción no es retribuir ni prevenir, sino su finalidad es incapacitar, ¿no? Finalmente. Comiso, pues claro, el comiso debe tener otra finalidad, ¿no? Que es ir a por las ganancias del delito. ¿Qué ha ocurrido? Que en algunos países dicen, bueno, a veces decomisar es difícil, ¿no? Vamos a ver si con una multa calculada en atención a las ganancias, de manera más fácil hacemos lo mismo que con el comiso. Entonces, claro, de pronto también han entrado en colisión el comiso y la multa, porque no se ha definido bien cuál es la finalidad de cada una de ellas. Bien, y con esto casi acabo, pero, bueno, dos cosas más. Al menos en España, uno de los grandes temas en materia de corrupción política, de gran corrupción, es cuando se asumen responsabilidades políticas. Es decir, cuando uno tiene que dejar el cargo si es imputado por corrupción. ¿Qué ocurre en España? Que se subordina normalmente la responsabilidad política a la responsabilidad penal. Y el tipo dice, yo no me voy del cargo porque gozo de la presunción de inocencia hasta que no haya una sentencia penal. Claro, como el proceso penal lleva una velocidad de caracol, pues ahí no dimite nadie. No dimite nadie, aunque haya 1000 escuchas diciendo que han pactado un soborno, ¿no? Probablemente otra de las funciones de las sanciones disciplinarias para altos cargos sería aclarar cuándo tienen responsabilidad política, es decir, cuándo deben dejar el cargo, ¿no? Y no supeditar, porque esto es una especie de bis in idem, ¿no? La lógica, oye, yo hasta que no decidan los jueces no me voy. Entonces, habría que ver cómo solucionamos esto, porque es muy importante desde el punto de vista de la percepción ciudadana, ¿no? Que alguien dimita del cargo. Bien, y luego otro problema sobre el que reflexionar son los macroprocesos por corrupción. Existe una tendencia, claro, la corrupción cuando se hace bien es una corrupción sistémica. Hay cientos de casos en la misma red. También por algo que tiene que ver con el mismo hecho desde el punto de vista procesal y en principio con buenas razones de economía procesal, ¿qué se suele hacer? Bueno, pues todos estos casos de corrupción vamos a agruparlos en un mismo proceso. La consecuencia de esto, en vez de la economía procesal, es la eternización del proceso penal, porque se hacen causas con cientos de imputados, con cientos de abogados. Aquello es un auténtico caos, ¿no? Entonces, también habría que pensar, los países al menos que tenemos este problema de macroprocesos, reglas para trocear los procesos que nos permitieran compartir de alguna forma información, pero que no obligaran, ¿no?, a hacer todo a la vez. Bueno, y esto, he intentado ser breve porque después voy a hablar también, es más o menos lo que les quería comentar. Muchas gracias.
Okay, I'm gonna go for English, which turns to be easier for me these days. So I have so first of all, apologies for not being here in the morning. I was flying over from Toronto, and as you have seen from the paper, my own paper with Lindsay Carson, we advocate for institutional multiplicity quite strongly. So my question to both of you is related to that. So my question to Anand Nieto is regarding your comment about the European Union and this concern with the bis in idem problem, which was resolved by a rule that says if someone is prosecuted in one of the states, that prosecution prevents prosecution in any other country, right? So tell me if this is wrong, but what I heard is that because of the inefficiency of Italian courts, a lot of people that fear being sued, they rush to an Italian court and propose a claim regarding a potential claim against them preventively, And since that will take many, many, many years to be resolved, they are sort of protected from prosecution in other countries by resorting to that. This is totally from hearsay. So my first question is whether this is accurate, and if it is, whether that wouldn't be an argument for what I call institutional multiplicity or modularity, but the idea that we could have two things going on at the same time, because if one fails, the other one will replace it. And the flip side of the coin is, I think Sarah was bringing the Redney case, which is clearly an example in favor of multiplicity, right? The state failed, so the federal prosecution took over and took care of matters. But I was wondering if you can think of any case in the US that would be the opposite. I mean, was there any case in which the double prosecution caused great concern about legitimacy, about fairness, about anything like that? Thank you.
Bueno, acabas de mencionar otro aspecto del ne bis in idem también que tampoco está claro. Vamos a ver, el ne bis in idem es claro, no doble sanción, no un proceso cuando ya ha concluido otro. Pero no todo el mundo piensa que también prohíbe dos procesos a la vez. Ese es otro aspecto que no está nada claro, ¿no? El problema que hubo, por ejemplo, en Italia, no es que la justicia italiana era lenta, sino que la persona llegaba a acuerdos procesales, por ejemplo, con los fiscales. Entonces, eso ya se consideraba que el proceso había cerrado, ¿eh? Si habían llegado a un acuerdo. O si los fiscales en Italia o en otro país habían archivado el caso, ¿no? Entonces, nadie se ha quejado demasiado de esta regla del ne bis in idem en Europa. Quizás los que más incómodos se sientan, hablo de colegas, ¿no?, de nivel academia, pueden ser probablemente los alemanes. Pero también, a veces, en algún caso de ne bis in idem que ha ocurrido con Alemania, se ve cómo influye la idea de soberanía en la comprensión de todo esto, ¿no? Hay un caso muy famoso de una persona que es en la guerra de Argelia, años 60, alguien de nacionalidad francesa o alemana mata en una pelea o algo así, mata a un ciudadano alemán, un francés contra un alemán que se enzarzan. Hay un proceso en Francia, se le condena a esta persona. Después hay una amnistía de todos los crímenes de la guerra de Argelia. Se libera a esta persona. Y en el año 2000, o después, Alemania todavía pretende perseguir a esta persona por unos hechos que habían pasado hacía 40 años y que no había ninguna necesidad de perseguirlo, ¿no? Por eso, la idea de ejercicio de un poder soberano, que es muy importante, como vemos en Estados Unidos, es que está muy presente a la hora de configurar la regla, ¿no? Y lo que ha dicho el Tribunal de Justicia de la Unión Europea es, yo prefiero la idea de ciudadanía europea, de que todos somos ciudadanos de un mismo espacio judicial, para mí prima sobre la idea del ius puniendi de los estados como ejercicio de soberanía. Ha sido la elección que ha hecho.
I can't think of an example that involves two different sovereigns in the political context that would meet your criteria of concerns. But I will tell you the kind of case that occurs occasionally that does cause people concern in the States. So remember, the Petite policy says that the federal government won't bring a second action unless it finds some federal interest demonstrably unsatisfied. Federal drug penalties are generally higher than state drug penalties, and some states will have drug courts, and people who sold a lot of drugs can potentially get a very low sentence, especially if they go into treatment. And it's possible, if there's a uniform federal notion of what the sentence should be, to regard that as contrary to, undermining that federal interest, right? So either that's a big success story because that keeps the states from thwarting this federal policy and results in a uniform equal protection, right? Or it's terrible, right? Because it's bad federal policy, basically. I think it's essentially bad federal policy. Would we imagine that something like that would happen in the context of political corruption or procurement fraud or something like that? It doesn't seem to me very likely. There is this fundamental question, if a jury has acquitted, which is where you tend to see the sort of strongest notion of double jeopardy, right? Should you ever let a second jury make that finding? And I think the reason the Supreme Court maintained that idea of dual sovereignty under the Double Jeopardy Clause when it rejected it for Fourth Amendment search and seizures, self-incrimination and so forth. So if the state police do an illegal search, they can't use that evidence, and they can't give it to the federal government to use either, because it's sort of all one government, right? But the Double Jeopardy Clause is, no, two different sovereigns. They can't bind each other. Why was that? And I think the reason that the Double Jeopardy Clause didn't get reinterpreted in the 60s by the Warren Court and otherwise is that it came up at the time of the civil rights movement, where Southern courts and Southern prosecutors and Southern juries were so unreliable and clearly acting contrary to federal efforts to enforce civil rights guarantees. So that's number one. And number two, it's such a strong card. It's one thing to say, if the state makes an illegal search and they get a hold of something, you can't introduce that under the exclusionary rule. If you can find other evidence legitimately, you can still prosecute that individual. But the Double Jeopardy Clause, if the state screws up, what is the remedy? It's a get out of jail free forever card. So it's the most serious consequence, and it came to the court at the time when it was most clear that the states were often acting in a way that was completely contrary to federal policy and undermining federal constitutional rights. So the court said dual sovereignty. Then in the late 70s, early 80s, they had a chance to kind of tweak it and narrow it. And I don't know why they didn't do it. Because it was state to state, not federal to state. So a man named Heath hired somebody to kill his wife. And he lived right on the state border between, I think it was Georgia and Alabama. And the killer abducted her from the home, and she was found dead across the state line. So the state where her body was found prosecuted first, and the defendant pled guilty with an agreement to avoid the death penalty. Then the home state prosecuted for the same murder to get the death penalty, and they got the death penalty. And the reason that both states had jurisdiction was the first state had a territorial rule that if a crime started in their territory, they could prosecute the whole thing. Right, so even though they didn't actually know that she had been killed in the home state, they knew she'd been abducted from the home. So you have two states with exactly the same interest. The interest in there's no sort of notion that it's a civil rights interest on the one hand and a just plain old assault on the other hand. They have exactly the same interest, and it's the death penalty. It's two states, it's not federal state. Supreme Court said, yep, Alabama can kill him. No double jeopardy. So they have not backed down. They have not backed down, and I don't see them backing down. And again, it was this notion that each of these governments is sovereign, and so long as Alabama really had a sovereign interest, right, then its interest in the implementation of capital punishment if the jury found under a constitutionally created statute. I thought that was a bad case, right? So that would be one that, again, it's outside of the area of political corruption, right? And it does go to this upping the ante. You know, if the defendant had known that if he pled guilty in the first, he would be giving them all of this evidence, and then they could just try the second time, right, to really load it up to go for the death penalty, he never would have pled guilty. I mean, that would have been, right, and maybe a little hint almost of collusion between the two states, right, and if they could have, anyhow. So I think it could go that far. And I think in theory under federal law, if the death penalty were available for a federal offense, if they'd killed Rodney King and if there had been a death penalty for that, and the first state had not been able to execute or had not executed, in theory that could be an exception for to the petite policy. So let's say Tim McVeigh, who blew up the federal building in Oklahoma City, or Zacharias Moussaoui, the so-called, 13th 9/11 bomber, right? If they had been convicted first in state court, would have been perfectly acceptable to go to federal court if the death penalty were available. And again, you can see the argument that it's really like your German, Italian, and the second state really hasn't gotten justice, right? It hasn't gotten the right penalty. But it does, from the defendant's position, look like facing jeopardy twice, right, for what seems like the same offense. And again, we don't have, even for the double jeopardy clause, we don't have the same transaction or same evidence test. We have the same offense, so that's narrow too. So yeah, I think you could see problems under our interpretation. But it doesn't come up a lot in the political corruption area.
Okay. Is this on? Yeah. Yep. Two comments, perhaps more than questions. First, if I'm, excuse me, may add to what Sarah said about elected prosecutors. We also have elected judges in many states. And so you're in Pennsylvania, where I live, all the judges from the Supreme Court down to justices of the peace at the local level are elected. So also they, for another reason, they also may not be less than courageous in dealing with political corruption.
Right.
Which most people in the world find bizarre to elect judges, but never mind. And secondly, I was really glad that I hadn't yet to mention the notion of code of ethics for dealing with corruption. There's this classic debate, you know, obviously the best way of dealing with corruption is not to have it. And there's this classic debate in public administration, particularly in Anglo-Saxon public administration, so-called Friedrich-Feiner debate. Karl Friedrich and Hermann Feiner, who were two German Jews who fled Germany just in time and were concerned about the excesses of administration. So they had this ongoing academic debate of how do you deal with excessive administrative action. Friedrich argued what you need is control. So you need to have strong institutional controls, legal controls, et.cetera., over the behavior of administrators. Feiner had to use the classic Latin phrase, cui custodis ipsus custodis, i.e., who's the guardian of our guardians? So no matter how many levels of control you have, you still have somebody who may act inappropriately. So his argument was the only way of dealing with corruption and malfeasance in public office was to institutionalize strong ethics, strong patterns of behavior, and in terms of what this project, in education, et cetera, and using those types of instruments along with the punishment to deal with questions of corruption.
Yo quería, bueno, muchas gracias thank you very much to both of you. Muchas gracias a ambos por los comentarios y las contribuciones. Yo quería contar muy brevemente qué es lo que nosotros encontramos en nuestra investigación en relación con estos temas. Y que en relación con eso quería decir tres cosas muy breves. La primera es que no hay un debate real sobre estos temas en ninguno de los países, probablemente porque no hay casos. La impunidad es tan alta en los temas de corrupción que rara vez alguien sufre una doble, triple, cuádruple condena, y en los muy poquitos ejemplos que hay, la condena social y las ansias de la sociedad civil por ver una condena, yo creo que previene a los políticos y a los previene un debate real, digamos, porque la presión, digamos, por las condenas es tan grande y se da muy, muy esporádicamente en muy poquitos casos. Creo que el único país donde hay casos, donde hubo algunos casos relevantes es Brasil. En el resto de los países directamente no existe esta discusión. Creo que la discusión en Brasil va a ser un poco más fuerte ahora con la nueva ley anticorrupción que prevé, dentro de la misma ley, prevé varias sanciones similares en distintos ámbitos. Al principio nosotros, cuando empezamos nuestra investigación, algo que miramos, por un lado miramos esto, por otro lado miramos también si había algún tipo de duplicación, digamos, de sanciones en el ámbito local e internacional, y algo que hicimos fue mirar tanto los casos de FCPA en Estados Unidos y en algunos otros países de la OECD, y las repercusiones nacionales, y me parece que es un finding interesante que no entró en nuestro paper todavía, pero es que no hay duplicidad de procedimientos cuando sería muy fácil y muy posible que los hubiera. Entrevistamos a algunos abogados que han trabajado en investigaciones de FCPA en los países en los que fueron parte de nuestra investigación, y la tendencia pareciera ser, viene un team de abogados de Estados Unidos o de Inglaterra o de Alemania, hacen la investigación interna, vuelven a sus jurisdicciones, cierran un acuerdo con las autoridades y evitan, incluso usando corrupción, que se abran investigaciones en Argentina, Brasil, Bolivia, Paraguay, donde fuera, básicamente porque los incentivos para cooperar en Estados Unidos o en Inglaterra, en los países de América Latina, son una confesión que no tiene ninguna consecuencia, o hasta ahora no tenían. En Brasil empiezan a tener con la nueva ley anticorrupción, existe la posibilidad de hacer leniency agreements ahora en Brasil, pero en el resto de los países esto no es así, entonces cualquier cooperación de parte del sector privado, que es algo de lo que vamos a hablar después del break, es una confesión lisa y llana que te genera, digamos, la peor consecuencia punitiva. Entonces, no existe esto ni con los casos de foreign bribery, de FCPA y UK Bribery Act y estos tipos de leyes de otros países de la OECD, ni tampoco con las sanciones de debarment de los bancos, de las instituciones multilaterales de crédito. Nosotros revisamos las listas de sanciones del Banco Mundial y del Banco Interamericano, y no estamos la razón acá no es la misma, creemos, pero no existe duplicidad tampoco de procedimientos. No hemos encontrado, digamos, procedimientos abiertos contra las firmas sancionadas o los oficiales públicos involucrados en los casos en los cuales estas firmas fueron sancionadas por los bancos. Y después un último comentario que quería hacer era que tampoco está en el paper, pero algo que Adam dijo en relación con España, que es que el principio de inocencia se utiliza para permanecer en los cargos hasta el último minuto posible. Es algo que en América Latina yo creo que ha cambiado mucho en los últimos años, probablemente porque los procesos judiciales, porque existe una noción de que los procesos judiciales, sobre todo los penales, rara vez terminan con una conclusión que no sea la prescripción, digamos, y entonces nunca se sabe qué es lo que realmente ocurrió. Y entonces hubo varias modificaciones, sobre todo en relación con las leyes de inmunidad, permitiendo que se hicieran investigaciones contra personas que gozan de inmunidad, siguen teniendo inmunidad de arresto, en general los parlamentarios en toda América Latina, pero se pueden hacer allanamientos o secuestros de objetos, tomar testimonios y seguir adelante las investigaciones. Y eso produjo, al menos en Paraguay, en Argentina, en Perú, un cambio de esta dinámica política, digamos, que hace que en general los funcionarios renuncien y se pongan a disposición de la justicia, en parte por alguna lealtad con el partido político, con la administración, etcétera. salvo con algunos deshonrosos casos, como es el del vicepresidente de mi país en este momento, que está procesado por corrupción y no sale de la administración, porque se ve como una debilidad política del gobierno dejarlo caer, digamos. Pero salvo algunas deshonrosas excepciones como esta, en general hemos visto en la investigación que es mucho más común que los políticos renuncien y como que la sanción más, la única, digamos, que se aplica en realidad es salir de la escena, por lo menos de la escena política fuerte. No quiere decir que después no vayan a una embajada o algún lugar donde tengan cierta protección, pero en general ese ha sido lo que hemos visto.
Olá, boa tarde. Queria fazer uma pergunta, uma consideração e uma pergunta sobre, não exatamente a questão da duplicidade de sanção, mas da duplicidade de investigações. Então, sobre a questão da prova emprestada, né? Porque me parece que diz respeito a essa ideia do Estado estar empenhando esforços duplicados para investigar o mesmo fato. E a posição do Supremo Tribunal Federal Brasileiro, para garantir o direito de defesa do acusado, diz que impõe limites à utilização da prova emprestada, né, no processo criminal. Então, a prova não pode ser trazida de outro processo para o processo penal se esse mesmo acusado não tiver participado e se defendido nesse outro processo. O que, do ponto de vista das garantias processuais penais, eu estou totalmente de acordo. Mas, do ponto de vista do desenho de uma coordenação entre esforços estatais para pesquisar, para investigar o mesmo crime, me parece uma burrice, né? Porque tem que refazer tudo, as provas já sumiram, as pessoas já não estão mais ali, a autoridade administrativa estava mais perto do problema do que o juiz penal. Então, do ponto de vista da eficiência do Estado, me parece um problema. Então, acho que a gente tem, na verdade, essa questão me incomoda, porque, de um lado, a gente faz questão, enfim, quando se discute os temas, se faz questão de que a esfera penal esteja presente por conta do seu potencial simbólico, mas o custo de trazer o direito penal para esse desenho, para um desenho de política como esse, me parece altíssimo do ponto de vista da eficiência do Estado, né? Enfim, eu queria só fazer esse comentário, porque me parece, do ponto de vista do direito penal, concordo, acho que está correta a decisão, mas acho que tem pouca reflexão, hoje em dia, sobre os custos de regular essas condutas pelo direito penal. A gente conseguiria fazer um desenho, conseguiria ser mais livre na construção de um desenho de procedimento se a gente tirasse o direito penal.
Bom, eu queria aproveitar para fazer só um acréscimo, uma indicação. Antes de começar, agradecer imensamente as falas da professora Sara, do professor Adam, porque as duas falas deixaram muito claro que, nesse contexto, que já era difícil, né, de pensar as questões de coordenação no âmbito da corrupção, talvez no campo das sanções e dos procedimentos, né, do desfecho dos procedimentos, a gente tem um problema ainda maior do que nas outras áreas. Porque aqui me parece que se quer algum tipo de consenso sobre a existência do problema, a gente compartilha. Então, se vocês perceberam, entre a minha fala e a fala do Guilhermo, tinha uma diferença entre a explicitação de que temos um problema para lidar. Isso é algo que a gente tem discutido, né, ao longo dessa pesquisa. Temos realmente um problema aqui diante dos nossos olhos, da multiplicidade de sanções, ou esse é um problema falso, uma falsa questão, porque justamente num contexto latino-americano, de um baixíssimo nível de enforcement, né, de persecuções tanto na área penal quanto na área administrativa, colocar um esforço enorme para pensar a multiplicidade pode ser algo ainda desnecessário, contraproducente, porque há um apoio da sociedade civil e de vários outros meios enorme para que possamos punir ainda mais, né, por intermédio do que tenhamos em mão, civil, penal, administrativo. Mas então eu vou agora colocar, ainda pensando também na provocação que fez a Mariana e no ponto que a professora Marta acabou de levantar, queria trazer um outro elemento aqui para a nossa conversa, especialmente no campo brasileiro. O CNJ criou, há 2 anos, uma meta para que fossem julgados os casos de corrupção e os casos de improbidade administrativa. Então, aquela ação civil que não é para compensação, é uma ação civil que termina com sanções pecuniárias e de possibilidade de perda de mandato. Bom, hoje no Brasil nós temos 45 mil ações tramitando, 45 mil ações de improbidade administrativa da esfera civil tramitando, e quase 70 mil ações na esfera criminal. Então, o CNJ contabilizou nos tribunais estaduais e federais o número de ações que nós temos relacionadas à improbidade e ao crime de corrupção. Então, nós não temos, claro, o CNJ não buscou esse tipo de informação, entre esses 45 mil e os 70 mil, quais deles dizem respeito ao mesmo fato, né? Mas nas entrevistas que nós conduzimos, e em alguns textos, poucos na literatura que discutem essa questão, aliado a isso, há uma meta da ENCLA, uma recomendação da ENCLA relacionada à duplicidade de ações na esfera civil e na esfera penal, tentando pensar justamente que é o mesmo órgão, o Ministério Público, é o mesmo Ministério Público que inicia a ação civil e que inicia a ação criminal. Então, diante dos... esse problema já estava visível, só visualizando os estudos de caso ou a legislação, mas com os números do CNJ ele ganhou uma proporção diferente. Porque agora a gente ainda não sabe, mas as pessoas que estão trabalhando diretamente com isso imaginam que há um número razoável desses 45 mil de improbidade, 70 mil de ações penais, que podem estar se referindo aos mesmos sujeitos pelos mesmos fatos, mas estão em salas, né, de um prédio do Ministério Público, nas salas diferentes, a sala do promotor penal e a sala do promotor civil. Bom, isso pode ser um elemento, uma questão, e a pesquisa mostra claramente, exclusivamente brasileira, porque em todos os outros lugares do mundo a ação civil é para indenização, é para compensação e não para aplicar sanções. Mas aqui esse é um modelo em que a duplicidade aparece de maneira muito, muito clara, com todas as questões de compartilhamento de prova que a professora Marta acabou de colocar. Então, essa questão, do meu ponto de vista, ela está muito num campo de invisibilidade, porque a gente projeta uma diferença muito grande entre a esfera civil e a esfera penal. Eles estão cumprindo 2 funções muito diferentes no mundo. E talvez essa seja a situação da improbidade com o crime de corrupção, em que a gente possa, talvez, desafiar essa formulação de uma distinção tão firme entre a esfera civil e a esfera penal. Bom, pergunto se Sara e Adam gostariam de fazer algum comentário final para a gente encerrar a mesa, tomar um cafezinho e recomeçar. Would you?
I think the U.S. tends to criminalize too much. So more things are criminal than need to be criminal. And then when we criminalize things, we tend to have 5 laws that deal with it or 10 laws that deal with it, rather than 1. That said, I don't think we over-enforce the anti-corruption provisions. And I think it's very healthy to have a competition of jurisdictions, more than one, that has the competence to do that. Whether we could improve, I think we certainly could improve the coordination of the investigative processes. You do have all of these different federal agencies. There are probably 100 different federal agencies that have some degree of investigative authority that might play some kind of role. And I know that they have some informal mechanisms for cooperation. So the different state inspector or the different agency inspectors general have a group. I think it's called SIGI, and they pool information and they do peer reviews of each other's processes so that they can develop best practices, and they try to be efficient and share information, so on. That's probably a good model that should be used in other contexts. We do use task forces. So for something like Medicare and Medicaid fraud, there are very frequent use of task forces that include state, because states have money in that too, state and federal, and they'll often try for a global settlement, which will include actors that could not bring their civil and criminal suits in the same court. It would be impossible to do that, but as a contractual matter by settlement, the defendants can agree, I will pay the state of Florida back, I will pay the city of Miami back, I will pay the federal government back, I will compensate these different people, and you can do that in a settlement, and then they would potentially plead guilty to one count, but also make these recoveries. So there is quite a bit of, at the federal level, use of task forces and global meaning grouping all together, not the whole world. Global, comprehensive is a better way of describing that. Comprehensive settlements. The BP oil spill out in the had a huge global settlement, which included pleas to manslaughter and the death of some of the people that were killed, and all the environmental offenses and so on. And they tried to get as much as possible into that comprehensive settlement. So those are probably models that are effective and efficient in some contexts. Could we do more? Yeah, I think so. And are there techniques or models that could be exported? I think that would be something that would be worth looking at.
Yo haría un comentario que, bueno, a la pregunta que me hacías, Maíra, claro, en España tenemos en el mismo procedimiento penal el proceso de reparación. Entonces, claro, este problema no lo tenemos. Ahí está unido. No es muy frecuente, pero entre nosotros es así. Y luego, un comentario a lo que decía Guillermo, es decir, que no existen casos, ¿no? Y una posible solución. Claro, imaginemos un caso de corrupción de Siemens en Argentina, que no hay que imaginarlo, fue real. De pronto podrían tener jurisdicción Argentina, Alemania, Estados Unidos, porque Siemens cotiza en Estados Unidos, más también el Reino Unido con la Brewery Act, porque Siemens hace una parte sustancial de negocios. O sea, podrían haberle 4 procedimientos distintos. Bien, alguna regla habrá que encontrar, ¿eh? Entonces, estoy pensando una regla muy interesante que tienen en el Estatuto de la Corte Penal Internacional, donde rige la subsidiariedad. Es decir, primero juzga el país donde han ocurrido los hechos y después, solo si no es capaz, pasa a la Corte Penal Internacional. Pero hay una regla muy interesante. Si en un país que juzga los hechos lo hace con el fin de cerrar el proceso en falso, poner una pequeña pena a quien ha violado los derechos humanos, etc. Entonces se habla de shaming process, es decir, procesos vergonzantes. Y ahí se hace una excepción al principio de ne bis in idem y después pueden ser juzgados por la Corte, ¿no? Una regla parecida podría aplicarse en materia de corrupción. Es decir, en el caso de Siemens, evidentemente, quien tendría derecho a juzgar en primer lugar sería Argentina, porque los hechos han tenido lugar allí. Solo en el caso de que cerrara el proceso de esta manera un poco falsa, con el fin de poner pocas penas, pasarían a tener jurisdicción el resto de estados, ¿no? Digo, podría ser una excepción en determinados casos al principio de ne bis in idem, ¿no?
So let me just say one thing that gives you an idea of the size. Bank of America just entered into what was said to be the largest comprehensive global settlement. And the Department of Justice press release said that 200 different federal and state agencies had been involved in this investigation. 200. And it was billions. I've forgotten what the settlement was, but it was a mega settlement, and about Bank of America, Countrywide, somebody else on all these false mortgage processing claims. So, you know, I think it's unlikely that you would have that large a number of agencies and entities, but it had different U.S. attorneys' offices, different federal agencies, different state offices, and so on. And then it was a very comprehensive settlement, and everybody had to be satisfied before it could be signed. So there is, even though all of those claims could not have been brought in any one court, Bank of America could agree, right, to do those things for all of those individuals and to take proactive actions, which is often required in the FCPA context. The company has to agree to have a compliance mechanism and so forth, the sorts of things that we hope would preclude corruption in the future.